Thanks a lot for joining today. Hope you all had a good and safe Thanksgiving last week. It's been a crazy year, obviously, and just want to say thank you to you all for all of the ways that you've served your clients this year and adapted to so many challenges. If we haven't met before, my name is Daniel Wilkinson. I'm the program manager for economic empowerment for Switchboard. I'll be facilitating today's webinar. I also have Saba Imran, our program coordinator, with me today. She'll be keeping an eye on questions and just providing some general tech support. So if you have any issues with the tech or anything, feel free to message Saba. So we actually set a new record for the highest number of webinar registrations for this webinar. So I hope that means that we have some new faces, some folks that maybe are new and just getting to know Switchboard. So if that's you, or if you just need a reminder, I just wanted to give a quick overview of who we are. So Switchboard is ORR's technical assistance provider. That means that it's our job to provide resources, training, and on-call support for you. And so Saba and I lead the economic empowerment and employment technical assistance efforts of Switchboard, and our partners over at the IRC. They handle a very wide array of topics, everything related to case management, mental health, monitoring and evaluation, youth, a whole lot of stuff. So if you haven't been to our website before, you can visit us at switchboardta.org, and I'd really encourage you to go there and sign up for our newsletter and blog. You can also submit a technical assistance request there, and so take a look. Before we get into the webinar content, we wanted to run through a couple features of Zoom. I think probably at this point in 2020, we're all pretty familiar with Zoom, but in case you're having any audio issues with your computer maybe and need to call in by phone or something, you can find the instructions for the phone numbers and stuff that you need to call in by phone by clicking that little arrow that you see there on the left-hand corner, bottom corner of your screen. We'll also be using the chat function and the Q&A function today. Feel free as we go to share comments. If you have any little stories or examples from your work as we talk through different situations, feel free to put those in the chat. You can also put your questions in the Q&A using the Q&A button. And you can also thumbs up questions if there's another participant's question that that you think is really relevant and would like to see that promoted and covered. So we're actually going to get started today with a quick poll. Excuse me. And Saba is going to launch that poll for us. So our question is, have the recent issues related to document delays, social security numbers, EIDs, et cetera, impacted the employment outcomes of your clients? So Saba, can you go ahead and launch that poll?
Sure. So I'm just going to give it another 5 seconds. Okay. I'm sharing the results now.
All right, so it looks like about 74%, about 3/4 of you said yes, that these issues are impacting employment outcomes of your clients. 6% said no, and 20% are unsure. So it looks like we picked the right topic today. We've also been hearing from a lot of service providers that that these issues have created challenges in their employment programs and are impacting outcomes. And so we're looking forward to being able to discuss some of these issues today. So as that poll just noted, one of the many challenges that employment service providers have faced in the past several months has been the delay of documents that are commonly used to prove work authorization. And so that includes Social Security cards, EADs, I-94s. This has put service providers in the position of trying to place clients in employment when they may still be waiting for a Social Security number or other document that's commonly used with employers. And you may know, and we know, that there are often legal ways to prove work authorization even without these documents. But often employers have questions and concerns, and maybe employers don't know that. And so what we're hoping today is to look at those situations, to talk about employment rights broadly, but really to focus in on employment documents and issues related to work authorization documents. So that we can just hopefully set you up to be able to have those conversations with employers and hopefully get over those hurdles. So on that note, our learning objectives today are to talk about the various documents that clients can use to prove work authorization, not just the ones that maybe employers are used to, but the number of documents that an employee, a refugee, an asylee, or our eligible client can use to prove work authorization for the I-9. We're also going to talk about some other things like background checks and E-Verify today. We also want to talk about strategies and resources that you can use when educating your clients and employers about employment documents and rights. And finally, we want to talk about discrimination and when is an employer discriminating? How do you know if it's discrimination or not? And what action should you take in those kinds of situations? So I'm thrilled to have Liza Zamd with us today. Liza is a senior trial attorney at the Department of Justice, Immigrant and Employee Rights Section. Liza investigates and prosecutes employment discrimination based on citizenship, national origin, unfair documentary practices, and retaliation. In her 10 years at the DOJ, Liza has developed substantial experience regarding issues affecting refugee and asylee populations, and she frequently travels throughout the United States to train attorneys, advocates, and employers about compliance. I've heard Liza speak before, and she's really great and helpful, and I'm really looking forward to having her help us get to the bottom of some of these issues. So Liza, thanks for joining us today. At the end of the webinar, we're also going to have a few refugee service providers join our conversation with Liza. I'm excited to have Katie Gibson, who's the program manager for Matching Grant at LIRS headquarters in Baltimore, as well as Sophie Golden, who's the employment specialist at IRC in Richmond, Virginia, and also Monica Harris, who's the refugee employment team leader at Catholic Social Services of the Miami Valley in Dayton, Ohio. Each of these service providers, whether they're on the local level or headquarters level, have been dealing with these issues, and each of them have some successes as well as some challenges to share, and are also bringing their kind of top questions for Liza today. And so I think you'll find that their experience is pretty representative and pretty similar to a lot of the things that you're facing. And so our idea today is not so much to have a formal panel discussion, but to really have a conversation circle, like it says on the slide. And we also want you to be part of that conversation. And so make sure as we go along throughout the webinar, as well as during the conversation circle time, to be typing in your comments and questions. So without further ado, I'm going to hand things over to Liza and let her share her presentation with us today.
Great. Thank you so much, Daniel. I really appreciate the opportunity to be here because, as Daniel mentioned, normally I travel throughout the US and I have done several dozen presentations to refugee service providers, maybe some of you, and I have learned so much from you, and I know that there's a lot of resources that my office has, and so that are helpful to you, I should say. And so I appreciate your participation today because hopefully today's presentation will make your lives easier and easier for your clients. I don't know, Daniel, if I have the ability to move the slides. Okay, thank you. So I think that it's helpful to first start with the following question. Which one of the options best describes your awareness and your experiences with the support that my office can provide? And you should feel free to click all that apply. So the first option is you've never heard of DOJ IER, but of course you're still looking forward to learning more. The second is that you know that the office exists. The third is that you know the office exists and you've used some of my office's resources, maybe some of the flyers that we have. And then the last is that you or employers that you've worked with have actually contacted my office and gotten support from us, directly. Okay, so I'll give it a little bit more time. All right, I know folks are still answering, but we don't have the most time in this world for today's webinar, so I'm going to end the polling. And it seems that 62% have never heard of the office. And so great, I mean, terrible, but also great in that you're here today, and so now you're going to learn. And so this is very helpful to know. And yeah, I'm sorry, Daniel, that I'm having problems still, unless you're the one who's moving it, in which case, thank you. So the most important thing that you will learn today is on this slide. It's the hotline number. And at the end of today's presentation, you're also going to get my direct email address. And you should always feel free to use me as a plan A, but you also have hotline as a plan B. And we have a hotline that's open from 9 in the morning to 5 in the evening, Eastern time, Monday through Friday, where anybody can call you, your client, employers, and ask us questions anonymously. You don't have to identify yourselves, and the calls can be in any language. We can get a translator on the phone. And so by far, this is the most helpful information that you will receive about my office, because even if you don't remember anything else from today's presentation, that's fine, because you'll know the phone number for where you can call to get that information. And so, as I mentioned, at the end of the presentation, you're going to get my personal email, not my personal, my DOJ email address. And I really encourage you to use me as a plan A, because I'm very familiar with refugee and asylee issues. But even if you don't use me, or I'm on vacation or sleeping, or whatever it might be, you can use the hotline as a plan B. So what does this hotline do, this magic hotline I'm talking about? Well, first and foremost, we handle a lot of Form I-9 issues. And I'm going to describe in great detail the Form I-9 and E-Verify process, because that's where we see a lot of discrimination. But we also handle other issues that maybe aren't a type of discrimination under the law that my office enforces, but that are due to misunderstandings or miscommunications that employers might have, where we can give them information to help clarify and resolve a problem. So that includes issues with background checks or electronic payroll, bank accounts, new immigrants where the bank is saying, nope, I need XYZ documents in order to open an account for a person. Things like social security number requirements that we're going to talk a lot about today. Maybe there's a situation where you see a job ad that requires US citizenship, but the vast majority of jobs are not allowed to require citizenship. There's auto extensions to your EADs. There's issues with E-Verify and SAVE. SAVE is the system that government agencies use, like the Social Security Administration, in order to see if somebody is in the US legally. And then there's also DMV issues or airport badging issues. These are all things my office commonly does. And so we're going to talk only about a subset of them today, but I wanted to let you know that the services that we offer are much broader. And so you should call me, because maybe this thing that is a problem for you is not something that I've seen before, but that I'm able to help. Or maybe I've done something about it 100 times and I know exactly what to do. And so you should please feel free to use my office as a resource. If you could advance the slides, Daniel, that'd be great. Okay, thank you. Okay, so here's our first discussion question. For those of you who have called IER's hotline, what are some of the issues that prompted you to reach out to the office? And you should feel free to put those in the chat. So employers asking for a green card. Yeah, absolutely. That's a problem for 12 different reasons, but we see that all the time. What else? Yeah, EAD cards that seem like they've expired, but they in fact have automatic extensions. Clients not having received their social security numbers yet, social security number requirements, US citizenship requirements. Yeah, these are all great examples of things that my office has done before and where we're able to help in these situations. So let's see if I'm, all right, so it seems that sometimes the slides work. So we're going to talk today about the 4 areas of the law that my office enforces, and they are citizenship or immigration status discrimination, national origin discrimination, unfair documentary practices, and we're going to spend the most time on that, and then retaliation. So citizenship status discrimination is when an employer who has at least 4 employees, so basically, you know, all but the very smallest employers, treats a worker differently in hiring, firing, or recruitment or referral. And they do so because the person's citizenship or immigration status. And so often we see employers who say that they only want to hire US citizens, or maybe they only want to hire US citizens and permanent residents. And they're just not allowed to do that. There's some exceptions to this rule. For example, if there's a law, regulation, executive order, or government contract that requires a particular citizenship status, then an employer is allowed to limit it. But these are very rare. And one thing that's interesting is that under some laws where employers are allowed to limit citizenship statuses, refugees, asylees, and permanent residents are part of the people who are automatically allowed to be hired. So maybe they are not allowed to hire asylum applicants, or maybe they can hire asylum applicants, but they have to get permission first. These are a different type of situation because refugees, asylees, and your SIV, your permanent resident clients, are not exempted from this law, meaning that an employer can hire them. And the reason why there's a lot of confusion is because some laws and regulations say that an employer can only hire a US person, but a US person is more than just a US citizen. And so if you ever come across a situation where an employer doesn't want to hire somebody because of their citizenship status, please let my office know, because most of the time they're not allowed to do that, and that can be a form of discrimination. And so when I say please let my office know, if you call us and say, hey, company XYZ is doing this, we can do an intervention, which is what I'm going to talk about for the bulk of this presentation, meaning that we call the company and ask them, you know, why are you limiting, you know, we're very friendly, of course, but, you know, like, oh, you know, just wondering why, you know, you have this limitation. And then we work with the employer if their limitation is not lawful. A person can also file a charge, which we'll talk about as well. You can file a charge, your client's best friend's neighbor's dog walker, anyone can file a charge. It's just that there's a process that's informal and a process that's formal, and you have the choice of either or both. One of the questions that I'm seeing right now is the US citizenship status requirement okay for federal jobs or government jobs? And the answer is, it depends. For most federal government jobs, you typically do have to be a US citizen, but for lots of state jobs, that is not the case, and it just depends on how the law is written. So for national origin discrimination, this is a little bit different because there are 2 laws that you might be familiar with that cover national origin discrimination. The law my office enforces and the law called Title VII of the Civil Rights Act of 1964. So under the law that my office enforces, we cover small employers, those that have between 4 and 14 employees. So unlike citizenship status discrimination, where we cover all, but you know, the tiniest employers, for national origin, we split this with a different agency. And so the Equal Employment Opportunity Commission, they cover national origin discrimination for larger employers, 15 or more. And national origin discrimination can be very broad. It can be where you come from, whether you have an accent, if you can speak English, the way you look, the way you dress, your name. These are all types of national origin issues And so if you have any concerns about them, also please feel free to call my office and we can talk about whether this is a problem or not. Okay, so next poll question. Have you ever experienced any of the following? Employers requesting specific documents for I-9 or E-Verify, saying, for example, that they want to see an EAD from your client. Employers claiming that other parts of the hiring process, like the background check or payroll, require a social security number, so they can't move forward with your client unless they have an SSN. Or maybe you've never experienced any of these issues before. And so let's see. I'll give it another 5 seconds. Okay. So it seems that about 60% of you have had employers requiring specific documents for I-9 or E-Verify, and also about 60% of you having employers claim that some part of the process requires a social security number. So it's great that you're here today. For the 20% of you that, or 18% of you that have never experienced before, well, you can learn something that hopefully you will never need, because all of the employers that you work with are wonderful. So either way, hopefully this will be helpful. So the next thing that we're going to talk about, these unfair documentary practices, are by far the most common type of discrimination my office sees. And they usually occur with I-9 or E-Verify. So I'm going to make you mini experts in how the I-9 and E-Verify process works. So this is the Form I-9 in front of you, and it's 3 pages. The first 2 pages is the I-9 itself, and then the last page is the list of acceptable documents. And the purpose of the I-9 is to verify that the person has permission to work and verify the person's identity. Those 2 things. The purpose of the I-9 is not to verify their citizenship or immigration status. It is not there for US citizens to prove that they are US citizens, or for permanent residents to prove that they are permanent residents, or for refugees to prove that they are refugees. That is not what the I-9 is for. That's not what E-Verify is for, and employers cannot make it for that. Why? Because there's a law that prevents that from happening, because it could be a type of discrimination, and that's the law that my office enforces. So here we have section 1 of the I-9, and workers should complete this section after offer and acceptance of employment, so it really should not be in an application packet. If you have a situation where it is in an application packet, please let me know, because my office can call the company and talk about this issue with them. And especially if it's in an application packet, you don't even need to identify who you are or who your client is, because it's for everyone. And so it's a very easy anonymous way for my office to try to look into the issue, and they would never know who it was who had told us about it. The purpose of the I-9, as I mentioned, is not to check any immigration status, not to check any document. It is only to check whether somebody's identity and work authorization generally. And so this section 1 is important because, in the top part of section 1, your client puts her name and her address and her social security number, if she's received it, email, things like that. But then this other part of section 1, this is where they mark what status they are. And so there's 4 options. The first is US citizen. The second is national. The third is lawful permanent resident. And all 3 of those statuses are terms of art. Those are specific statuses. And that 4th box, alien authorized to work, it's like the kitchen sink box, meaning that if you are not a citizen, national, or permanent resident, you are that 4th box, alien authorized to work. And this is important because citizens, nationals, and permanent residents are permanently work authorized. But there are some alien authorized to work that are permanently work authorized, like refugees, asylees, people from the Marshall Islands, and Palau. And then there are other people who are not permanently work authorized. like asylum applicants or people with deferred action, DACA. Those folks have an expiration on their authorization to work. And I mention this because this NA that you see in front of you, it says alien authorized to work until. If you have refugee, asylee, or the folks from the Palau, Micronesia, Marshall Islands, they should put NA in this field. And it's really important to explain that to them, because if they put a date in that field, like the date of their EAD expiration, the employer must get more documents from them. And so it's really important that they put NA. And sometimes employers say, no, you can't put NA, you need to put a date. Well, the I-9 is so helpful. And it says immediately underneath that line, some aliens may write NA in this field. And those aliens are refugees, asylees, and the folks from Micronesia, Palau, just to name a few. So if there's a software program, for example, that requires a date and you can't put NA, please let my office know, because this is, again, a really big problem. So now you get to Section 2. And Section 2 is when the employer first takes a role in this I-9, because Section 1 is what the worker filled out. So employers should never say, oh, I want to see a document with your alien number on it to make sure you wrote it correctly. Or I want to see a document with your I-94 number. They're not allowed to do that. And so maybe your client wrote their I-94 or their A number on a piece of paper, and that's how they're writing it down. Maybe they memorized it. Maybe they called their mom and their mom read it to them over the phone. It doesn't matter. They do have to put in an alien number or I-94 number, but employers are not allowed to ask for a document to verify that information. So then for Section 2, this is a situation where now the employer is involved in the I-9. And workers get to decide whether to choose a List A document, which shows identity and permission to work, or workers can choose a B document, which is identity, and then a C document, which is permission to work. So either an A or a B with a C. And when you see here, there's like a line that goes down the middle of the I-9, and this is to try to explain to workers that it's not an A and B, it's just A or B and C. There's a question here about whether we have a document to share with employers. Oh yes, we have many 1- or 2-page flyers that have all of this information in them. And there's other resources as well. So then what's the thing that's illegal? It's illegal for an employer to request more or different documents, or reject valid documents, or specify the documents that they want because of somebody's citizenship status or national origin. And this happens all the time. And in fact, if any of you are in Phoenix, please take my email address down at the end and email me, because my office just settled our largest case ever, where an employer was requiring mostly refugee and asylee clients to show an I-94 or an EAD in order to get hired. But maybe the workers had a driver's license and an unrestricted social security card that they wanted to show. And for this employer, Fleet Logic, it was not enough. And so definitely email me at the end, because we have a back pay fund for any workers who lost work because of this. So now we also see that there's a lot of common questions to the I-9. So for example, your client's EAD has expired, or has it? If your client has renewed their EAD and they've kept it under the same, for example, refugee status, meaning they've not applied for permanent residency, then there is a 180-day extension to that EAD. And right now, there's also another extension until February for people who have been approved for a new EAD but haven't received it yet. There's also a lot of questions about receipts for lost, damaged, or stolen documents. If I lose my driver's license and I get a receipt for a new one, that receipt is valid for 90 days, even though maybe on the temporary driver's license, it says, I'm sorry, not the temporary driver's license, maybe on the receipt for the driver's license, because a temporary license is something different. Maybe it says it's only valid for 45 days. It doesn't matter. For the I-9, it's valid for 90 days, regardless of, for 90 days from the date that the worker gives it to the employer, not 90 days from the expiration date on the document or the issue date on the document. We also see that sometimes employers don't realize that transportation boarding letters, you know, the letters that your refugee clients get that have their photos and then the stamps underneath it, and it's the photos of all the family, those are valid identity documents. That's a List B document that your client can use. And so if the employer is like, I don't know, it's got like a baby on it and, you know, a bunch of other people who aren't getting a job here, that doesn't matter. They're not allowed to reject valid documents just because of somebody's citizenship status or national origin. And sometimes people also don't realize where the expiration dates are on documents. For your SIV clients, the ones that have the machine readable immigrant visa, on the face of the visa, it has an expiration date in the corner, but that's just by when your client has to enter the US. There's an I-551 stamp that goes next to the visa, and that visa is a List A document for a year after that I-551 stamp. And so again, you don't have to memorize this because now you know who to call if you have any questions. The last thing is I-94s. And so there's a whole slide on this. There's a lot of questions now about the receipt. The receipt rule is for literally any I-9 document. It doesn't matter what the document is. If any I-9 document has been lost, damaged, or stolen, and you get a receipt for that document because you've applied for a new one, that is a valid I-9 document. Again, lost, damaged, stolen, not renewed, lost, damaged, or stolen. That's the receipt rule. Okay, so I-94s. I-94s are a little bit complicated, but that's why we have this very handy chart. So a refugee I-94 is a valid List A document for 90 days. And at the end of those 90 days, the refugee has to give either an EAD or an ID and an unrestricted social security card. The refugee gets to decide. It's not the employer's choice, it's the worker's choice. For asylees, it's different. Their I-94 is a List C document that never expires. And so although the refugee can only use the I-94 for 90 days, for an asylee, they can use that I-94 forever, meaning that the employer should not be getting another document from them. So if the asylee shows an ID and their I-94, that's it. No more documents are needed. For permanent residents, the I-94 is a List A receipt valid for a year, meaning they're going to get a stamp on that, and it's valid for a year from the stamp. And so I know that there's a lot of confusion about this, but again, there's things that you can, call us about. And there's a great question here. Are there any exceptions to the rules because of COVID? Yes, there's a lot of exceptions. For example, List B documents that expired after March 1st are still valid. So if it expired March 2nd of 2020, your client can still use it. And so we don't have enough time to talk about the COVID exceptions, but definitely there are lots of COVID exceptions because of this issue. Okay, so we've breezed through Section 1 and Section 2, and now Section 3. This is where the employer needs to see whether some of its workers are still authorized to work. And so I had mentioned before that if a worker puts an expiration date in Section 1, now the employer is going to have to complete Section 3 for them. Another situation that your clients would have is if the worker shows, for example, an employment authorization document, an EAD, the employer will have to do re-verification for them. But the rule for re-verification is the client gets to show any List A or List C document. And the reason why List B is not needed is because they're not wondering whether the person still has the same identity, right? And List B is only identity. They're wondering whether that person still has permission to work. So the worker gets to choose to show a List A or a List C. So if your client only has an EAD and an unrestricted social security card, they don't have a List B document, the best thing is to show the EAD for Section 2, because they don't have a List B to go with that social security card, but then immediately, that same second, show that social security card for Section 3, and then the employer doesn't ever have to get documents from that worker again. And so there are some tricks that can make your and your client's life a little easier. and then that might be helpful. There's something that folks are saying about the I-94. Refugees who arrived after 2015 can download their I-94s offline, but if you arrived before then, you cannot, and asylees are not getting these electronic I-94s, at least not that I'm hearing. You would, of course, know better. And with those I-94s, there might be an expiration date, the ones that you print online, there might be an expiration date. That is not an expiration date for that I-94. It's actually totally irrelevant to the validity of the document. But sometimes employers are rejecting them, so some people decide to just print out a new one. But if your client can't print out a new one, they can call my office and we can talk to the employer. Okay, so I had mentioned before that EADs require re-verification. What else requires re-verification? Well, temporary visas. These are things that your clients normally aren't going to have because they're not here on a visa, but certainly the employment authorization document and then the temporary I-551 stamp. And so that machine readable immigrant visa, that's the thing on the right. That's the thing that your SIV clients get. The temporary visas on the left, which is actually a photo of an old I-94, these are things that people would get if they are coming to the US on a work visa. So that's not really as relevant. Okay, so next question. An employer wants to hire your client, but says that even though your client has enough documents to prove their identity and permission to work for the I-9, the hiring process cannot move forward because E-Verify requires a social security number. So what would you do? First option, nothing. The employer's got to be right? Because they hire people all the time. B, well, maybe try finding an employer that doesn't use E-Verify. C, tell the employer that they're discriminating and that you're going to report them. Or D, acknowledge their concerns and offer to share resources to address the situation. So the question is, what would you do in this situation? Let's give it a couple seconds more. Okay. So the vast majority of you would do the fourth option, would be to explain resources. And in this situation, there's one wrong answer, which is of course A, nothing, because the employer must be right. And I say that it's wrong because the employer is wrong. That's just not how E-Verify works, and the employer is incorrect about it. But depending on the situation, options B, C, and D, which by the way are not mutually exclusive, you can do all of them in tandem, are things that you can consider. And so one of the things that we're going to talk about at the end are different strategies that people use and maybe escalation topics. Okay, so now you've gotten to an employer that uses E-Verify. E-Verify is not this system that totally changes everything about the I-9, but it does change three things about the I-9. First is that the worker, if they're going to show a LISP document, it has to have a picture of them on it. But, you know, transportation boarding letters have photos, right? Second is that if the worker has a social security number, they have to provide it. And third is that the employer does need to make photocopies of certain List A documents if the worker presents them for the I-9. And so if the worker presents a driver's license and a social security card, the employer is not allowed to say, oh, well, I need to make a photocopy for E-Verify. No, that's not what's happening at all, because the worker showed a List B and a List C document. There's no photocopying requirements for those. And so employers are not allowed to ask for specific documents just because they happen to use E-Verify. So one of the questions here is, can an employer use either I-9 or E-Verify? And the answer is no, because E-Verify is on top of the I-9, meaning that you have to use the I-9 first, which every employer in the United States must use for every employee. And then some employers use E-Verify after the I-9, but they're not interchangeable. So there's a lot of resources for workers and employers regarding this issue of workers who do not yet have a social security number. And we put some of the resources in the slides below, and you'll be getting a copy of this presentation. You'll have access to it so that you can literally just click on the links and it'll bring up the resources that talk about how employers should put the I-9 aside until the worker gets the social security number, and then they run E-Verify. But during that time, which who knows, now during COVID, it could be 4 months, 5 months, even longer, the person should still be working. So the last thing that we're going to talk about before we do our panel is intimidation and retaliation. This is basically protections against workers who are trying to assert their rights or the rights of others. And this is important because oftentimes when refugee service providers haven't used my office's hotline before, they might not, they might be afraid of, what might happen. And if an employer were to get mad at a worker and not want to hire them because my office did a hotline intervention, or maybe because you said to the employer, hey, employer, just so you know, my client can show a driver's license and social security card. They don't have to show an immigration document. Any of those things, if the employer gets mad and takes any negative action against your client, they decide not to hire your client, or maybe they hire your client, but for a lower wage or anything that's negative, that is protected under the law my office enforces. And so thankfully, I've worked in this office 10 years and I've yet to have a retaliation case because of a refugee or asylee hotline intervention, but it is possible. And so that's just something that you should know. And I think ultimately, one of the things that might make you feel better is that oftentimes employers, they're confused, right? Like sometimes employers don't want to hire immigrants, and that's not a confusion on their part. Like that's just, very, that's like an animus, a discrimination where they don't like people from other countries. But then there's other employers who might want to hire your client, but they're just really confused about the process. And so they are thrilled to learn that there's a hotline that they can call when they have questions about an I-9 issue or an E-Verify issue. And maybe it's something that's totally unrelated to your client, but they can call the next time something arises, maybe doesn't even have to do with a refugee or asylee. So often they're really grateful to learn about my office and the resources that we provide them, not just the resources that we provide you. And one thing to note about these retaliation protections, they are for any worker, even undocumented workers. So it doesn't matter what your status is, you are protected from retaliation. So if a worker wants to file a charge, or if you want to file a charge on your client's behalf, or like I said, the person's mother or neighbor, whoever, doesn't matter. The charge forms are available in, I think, 15 different languages. And the worker or whoever it is that's filing it must file within 180 days. And saying that they were scared or they didn't know, or that's usually not an excuse. And so it's really important to file the charge within 180 days, if that's something that the worker wants to do. Of course, if the worker wants to have an informal intervention and no charge, that's fine as well. So we have here some recommended resources that I won't spend too much time on because I don't want to take time away from the panel. But ultimately, these are the same resources that my office shares with employers. And these are the same resources that if you want, you can share with employers. And they're publicly available, they're from the government. Some are more digestible than others, but they have like very concrete information about what employers can or cannot do. And so here you have my email address and my phone number. My office line, I'm not in the office now because of COVID, and so you can leave a message on that line. But if you want to get in contact with me directly, calling my cell phone or calling my email address is the best way. And I am very fast. If I don't respond to you in 12 hours, it's because I was hit by a truck or something, because I know how important it is for you and your clients to be able to resolve these issues. And so I don't let time pass by. I know that it's super important that you get responses, because sometimes these jobs, there might be an opening now, but maybe there's not going to be an opening tomorrow. And so I try to respond immediately, but 12 hours is usually the max amount of time that it might take for me to respond. Okay, so I'll hand it back to you, Daniel. And I think you might be on mute, Daniel.
Can you guys hear me now? Yeah, okay. It looked like I was unmuted, but I guess I wasn't. Thank you so much, Liza, for sharing your expertise and experience with us. Obviously, these are not simple simple issues, and we're not suggesting that there's a simple fix in every case, or that even the right answer is simple to apply. But I think that this has been really helpful for all of us today. So just want to remind you all to type any questions that you have in the chat. We will be coming to some of your questions. And let's see here. Lisa,
So
are you
Daniel,
able to give me, hold on one second. Oh, I can do it myself. Okay, I'm good. Go ahead, Lisa.
Well, so I noticed that there's some questions in the Q&A that have been pushed up by some other people, and then some questions that people were putting in during my presentation that might be helpful for me to answer. And I'm wondering if you want to spend a couple minutes with me doing that before we do the panel, or if maybe that's something you want to do after. Yeah,
I was actually just messaging with Saba as well to say if there's some burning questions from attendees before we get into our conversation panel, we could address some of those. I forgot to share this in the beginning, but just because of the high interest on this topic, we are going to stick around. Liza and our panelists have agreed to stick around till 3:15 Eastern Standard Time, so we're going to go an extra 15 minutes. And so certainly no pressure to stay longer than an hour if that's all you've got, but we're going to stay to continue the conversation till then. So yes, if there's a couple things, Liza, that you already saw, or Saba, if you want to recommend anything, we can do that and then go into our panel time.
Sure. So one of the questions, the one that has the most upvotes, is for asylees who haven't received their I-94 yet. And actually, even though the office is closed, one of the exceptions for the InfoPass appointments is for asylees to get their I-94. And so what needs to happen is the person needs to call USCIS and say that they're an asylee who doesn't have an I-94 and needs it in order to, for example, to begin working. And if you have any problems with that, you should let me know, because we have now talked with USCIS about these issues that we're seeing. And I have heard of more than a dozen people, more than a dozen asylees now being able to get these InfoPass appointments. And so you should escalate it to a supervisor if the person that you're talking to says that that's not one of the reasons why they can get an appointment, but that is that's a policy that USCIS has. Asylees who don't yet have their I-94 can get an InfoPass appointment. Somebody had also mentioned before that sometimes employers might have working interviews where they're like, yeah, just come here for the day and work for us. And there's no slavery in the US, meaning that people must be paid for all the work that they perform. And if they're performing work, then the employer also should be filling out an I-9. Now, if the employer is not filling out an I-9, you might not care. And my office, we enforce discrimination issues, whether an employer is doing the I-9 process, from a technical standpoint, is not something that we look into. But certainly every person needs to get paid, even if the person is undocumented. They always need to get paid for the work they've already performed. And so employers are not allowed to use also the I-9 as an excuse not to hire someone. If they hired someone and the person doesn't end up having sufficient documents for the I-9, they still need to pay that worker because of a totally separate law that requires payment for all work that's performed. And so these are the kinds of questions where We don't enforce these laws, but I'm happy, my office is happy to give you information and assistance about these issues too.
Great, thanks. Saba, I don't know if there were any other burning questions from the audience that we want to touch on before going into our conversation time.
Right, just one quick question. Somebody asked if client's driver's license is not renewed because their employment authorization card has expired and they do not have a PR card in hand yet. What can they do?
Yeah, and sorry, the driver's license wasn't renewed because the client doesn't have what? I'm sorry?
Because their employment authorization card has expired and they don't have.
Okay, so different states have different rules, and some states allow workers to show the I-94 to prove their lawful presence in the US. And so, for example, in the state of Virginia, you can't use an EAD to get a driver's license. You can use the letter from immigration that your client receives when they apply for a new EAD, but you can't use the EAD itself because that's just how the state law works. So every states are different. But what my office does is if a state is doing it wrong, we will call that DMV and we'll call headquarters and we'll explain the situation, and then headquarters will call down to the office and educate it. And these aren't adversarial calls. It's not like, oh, you're doing this wrong. It's, oh, there might be a misunderstanding about, which documents are allowed. And so we'll research it, find out if the documents that your client has are documents that under state law are allowed to be used to receive a new driver's license, and then we can contact the DMV. And so that's how our interventions work, because even if it's with an employer, which is like squarely within the thing that my office, sues companies for, we're not investigating with interventions. We weren't there, we haven't interviewed anybody, we haven't looked through documents, we're just forward thinking. And so instead of trying to figure out like, oh, who said what, like that's not what the question is. The question is, now that the employer knows about what the correct process is, how can we get this person onboarded if that's something that the worker wants and something that the employer wants?
Great, thanks for those answers. So let's move forward. We had a couple recommended resources as well that we just wanted to recommend in case anybody does leave at 3 o'clock. We wanted to make sure to get these in here. We recently did a blog series called Refugees and Asylees Have the Right to Work. And it was a 2-part series and really looked at a lot of these kind of documentation issues that Liza's been talking about, as well as some common concerns like, well, this might be legal, but this doesn't work in the real world, or well, what about burning bridges with employers? Some of those common concerns that we hear, which we'll probably talk about a little bit today as well in our conversation circle. Also, you might find HIRE's job readiness curriculum helpful, and you can find that in the Switchboard resource library. Sections 7 and 8 deal specifically with employment documents and employment rights. And then finally, if you're looking for things to actually give to employers, I would recommend the U.S. Employer's Guide to Hiring Refugees that was produced by the Tent Foundation and LIRS. And there's a section in there that talks about commonly held documents and also a lot of other great information for employers. And so that might be a great thing to include in some, if you have like a packet or along with your brochure for your program or things like that. So let's open up our conversation circle time. And so what we tried to do for this was really to find a few people, because we've been reaching out to a lot of folks, and we also get technical assistance requests, and we also hear from ORR and others about issues going on out there in the field. And we knew we wouldn't be able to get to everybody's questions today. And so we sort of tried to find some people that could talk about the things that we're hearing about most commonly. And so we will get to a few more of your questions if we can, but hopefully you'll also hear your own situation in some of the snapshots that our panelists share here. So I guess we'll just go from left to right on the slide. Katie, do you want to start us off and just talk a little bit about your experience from kind of overseeing a matching grant network and what you're hearing from that network and what's going well, what's not going well?
Yeah, thank you. Gosh, guys, I've learned so much every time. Thank you, Liza, so much. So from the national network, we've seen, like everyone has been saying, it's the delays. It's the delays in all the documents, especially with COVID, has really impacted all of those things. I will say, though, even previously, before COVID, not having a social security card was a major issue with employers. Not having that number, and like so many people have said in the chat or in the Q&A function around that E-Verify and that I-9 process. So in terms of like the advocacy with the Social Security Administration, make sure that you guys are reporting any issues to your headquarters and to your state refugee coordinators in each of your states. Some states are better than others, and also each office is really particular. Try to speak to a supervisor, try to get people through. I know the timelines have kind of ebbed and flowed on that, and we've seen that in every state that we're in. But really, I think something that, Liza, if you can touch on a little bit more, is around this like advocacy with employers. Like if they're saying that they can't get through the E-Verify system without a social security card, what is someone's response to that?
Yeah, so I view it as sort of different levels. So level one might be, hey, employer, here's some documents from the Department of Justice or from the Department of Homeland Security that explain how you, the employer, can, still hire the worker without a social security number. Level two might be contacting my office, and maybe we can send you an email that has those same links. And so you're like, hey, so, contacted the Department of Justice, and look, they actually sent me, this information, because maybe the employer, I don't know, might not think that the links are valid, or might not think that the links are current, whatever it might be. And then level three might be where you call my office and we contact the employer directly. Because ultimately, employers are not allowed to change the I-9 and E-Verify process, meaning there was a question that I just answered in the chat about what if the employer says that their payroll system is linked to I-9 and E-Verify. And the answer is, I'm so sorry for that employer, because they are not allowed to have systems that modify I-9 or E-Verify. It's against the law, it's against their contract with E-Verify, like they're just not allowed to do it. And so oftentimes employers are unaware of this. And so they might be excited to learn about it in a soft way, like from an IER intervention, versus if they were to get an ICE audit, because ICE just randomly audits employers. So, it allows them to take corrective action. And one thing to note is that my office doesn't share information with ICE. So we don't tell ICE where we've had hotline interventions, like that's just not what we do. And the only situation where we would contact ICE is if we think there's human trafficking, which thankfully we've not come across that in the 10 years I've been with the office. But I think that, trying to start with the resources is an option that, you can choose, but you get to decide. So my office is just here as a tool to help you. So if you want to start off on your own, great. If you want to go directly to a call from us, fine. It's whatever you have the time for, it's whatever you have the comfort level for, but certainly not addressing it, which is also your choice, means that the problem will continue and will continue for other people. And so ultimately, like, that's a less helpful option in terms of making sure that workers who have permission to work, get the jobs that they are otherwise entitled to.
Thank you so much. I've actually called before, and I can speak on that at another time, but it immediately helped my situation, so.
Great. Thanks, Katie. And we also had there was another person who was going to be on the panel that wasn't able to join from, his name is Nasser from Nationality Service Center in Philadelphia. And he actually wanted to share something related to what Katie just said. He said about a year ago, our employment team placed one of our refugee clients at, I won't name the name of the hotel, but at a hotel as an overnight auditor. When his EAD expired, his employer, who was unaware that refugees have the right to work indefinitely, demanded to see his green card. One of our job developers spoke with the employer and provided the DOJ hotline. The employer then apologized and stopped his threats to illegally fire our client. And so, yeah, so we're getting more reports that this is going well, and that calling Liza or her office, that it's not something that is like a scary thing to do, but that it's actually really helpful. So let's go to Sophie. Tell us a little bit about what's happening in Richmond, Virginia, with your clients there.
Yeah, so recently we have had some success using guidance documents from US DOJ just to walk employers through the I-9 and some of the documentation that our SIV and refugee clients have. But as many have mentioned, there have been a lot of issues since COVID with Social Security cards and those delays. I was wondering if you could speak directly about how you address issues with background checks and Social Security cards. What do those conversations with employers look like?
Yeah, so that I think is one of the most prevalent problems that we see, is that employers are saying, look, I know for E-Verify and the I-9, I don't need a Social Security number. We're on the same page with that. But for a background check, I need it. Or for payroll, I need it. And so payroll is a pretty easy problem to fix. There's lots of information, some of which are on the slides, and the employer can get educated that way. For the background check, that's a more complicated issue. And employers are often unfamiliar with the background check process because it's a third company who's doing it, a third party company who's doing it. And so often what my office will do is we'll contact the company and we'll talk about, for example, if they're requesting documents, which has happened, it's an intervention that I did earlier this summer, where they wanted a document from the person from their home country. But the person's like, I don't want to tell you anything about my home country. I don't want you calling them. Like, I fled my home country. I don't want them knowing where I've been resettled. And the employer just had no idea that this was happening. And so requesting documents because of somebody's national origin, like, that's a problem. Also, I ask questions like, okay, employer, but what if somebody is convicted of a crime in another country, but that crime is not illegal in the US? What if they're convicted of drinking alcohol in one of the countries where alcohol is forbidden? What if they're convicted of being gay? What if they're convicted of speaking out against the government? And then also, their convictions might not say any of those things. Maybe the convictions will say, sexual deviance or something for, or sexual assault for being gay, or terrorism for speaking out against the government. How do you, employer, read these results? And oftentimes the employer, they just hadn't thought of it. And then lastly, employers usually are not doing this with US citizens, meaning that they might go back 7 years with a US citizen, just like they do with a non-citizen. But if that person lived abroad, they're not asking for that person's information from when they lived abroad. They're just checking to see if in the US they have any criminal background. So you do not need a Social Security number for a criminal background check. If your name and date of birth are sufficiently unique where the background check company can be able to disambiguate you from somebody else. So if you have a client whose name is John Smith, I'm sorry, like, that might be a situation where the background check company is not going to be able to tell because there's too many hits. So most of the time your clients are not named John Smith. And so in those situations, my office contacts the employer. Often we'll jump on a line with, jump on a call rather, with the employer and the background check company. And many employers, after seeing all these issues that they hadn't realized and all these barriers that they're putting in front of people that might be discrimination, they decide to change. Because one important thing that I didn't mention is that the Equal Employment Opportunity Commission, they have guidance that says that it can be a type of national origin discrimination if an employer is requiring a Social Security number from a worker and the worker doesn't yet have one. So these are all things that I talk to the employer about, since often the employer is just unaware.
Well, thanks so much. I know that your response time is very impressive from personal experience, so I appreciate all of your work.
Great, thanks so much. Monica, tell us about Dayton.
Yeah, so I'll also echo what Sophie said. Liza's response time is super fast and it's very helpful and very thorough. So we've had a lot of similar issues that many of you have had. We have had some success placing a few employees in jobs where without their social security number. So but in both cases, these are employees who already had their EAD. And what we had to do is show, well, what we did, I shouldn't say had to necessarily, but what we did is show the receipt showing that our clients had applied for their social security number. And then when the employers came back and said, well, what about E-Verify? We sent them the links to the specific sections in the E-Verify manual about how to handle that for people without social security numbers. We've had some success with that, but we've been running into similar issues as what Sophie mentioned with background checks. So one thing I kind of wanted to tag on to what she has already said is with the EEOC guidance. Lisa, when you had emailed me about that, you mentioned about how employers would have to show business necessity or that the background check is directly related to the job. So I guess my question is, aside from like what we've already talked about with like federal government jobs, things like that, what types of positions and I guess jobs, employers, et cetera, would meet that standard? How easy or hard is it to meet that standard?
So I don't think there has been a case brought yet that has flushed that out. I think that there have literally been 0 cases brought with under this national origin guidance. It came out in, I believe, 2016, and in order for the EEOC to bring a case, or for somebody to bring their own private case, they need to file a charge. And so I don't know that any charges have been filed either. So it's a whole new world in terms of whether and how an employer can prove that this business necessity, really requires that social security number. But, I would also note that for a lot of employers, they don't realize the background screening that the refugees go through, and that there's the FBI and, DHS, and that there's so much vetting that happens before a refugee ever steps foot into the US. And so it might be hard for them to show because like this person has already been, very heavily vetted and screened. And, it just depends, but it's an open question since I don't think that any cases have been brought.
Cool. Did that help, Monica?
Yeah, sorry. No, thanks. Yeah, it's interesting, I guess, to me that there hasn't been anything brought. I feel like that's probably something that has happened. But I think probably like many of us, there's a fear of burning bridges with employers too, right? Like even if we wanted to, or if a client wanted to, pursue that, like what about all the other clients who have always, been hired by the employer before and how, so yeah.
And the EEOC is much larger because they also investigate race discrimination, sex discrimination, disability discrimination. So they don't have this informal intervention system like IER does. But oftentimes, and I know that it might not have been a satisfying answer to you, but these issues can be resolved just through the phone call. And so maybe one of the reasons why the case hasn't been brought is because the refugee service providers will contact IER instead, and we're able to resolve it at least to the person's satisfaction. But I know that it's not super satisfying to say who knows what the answer to your question is, but that's in fact where it stands right now.
No, that makes sense though. Thanks.
Great. Saba, do there seem to be any other very common questions or burning questions from the attendees? I just want to make sure that we are weaving those in as well.
Yeah, I think there are questions around expired EADs. They're coming up again, and if somebody has a question, if a worker has already been terminated due to an expired EAD, what can they do?
Yeah, so I'm always happy to try the intervention. Obviously, the further away it is from the termination, there are 2 pressures. One is that if your worker, if your client rather, or if you want to file a charge, as you're approaching 180 days from the date the person was fired, you know, the intervention might not give you a ton of time. So if you're at day 160, I might be able to do an intervention and get it fixed immediately, but maybe not. And so, you know, you always just need to keep track of that clock in the back of your mind. But I've gotten people a full year of back pay before, because the employer is like, oh, this is bad. We are so sorry. And they realize that what they did was wrong. And they also realize that the worker is able to file a charge, or maybe that worker has already run out of time, but maybe the 20 other workers who they did this to have not run out of time. And so they want to do whatever they need to in order to fix the problem, because fixing the problem by giving back pay is probably going to be cheaper than having to hire an attorney to respond to my office's investigation. And so if you have a client who had an EAD and it expired and the worker fired the client, and the client wasn't given the opportunity to show, for example, an unrestricted social security card or an I-94, because you can use the refugee or the asylee I-94, or any I-94 for a permanent resident as well, for re-verification, then yeah, contact me, because I'm happy to try the intervention. And if it doesn't work, then, you know, we can talk about the other options. Or maybe your client just wants to file a charge because he or she is upset. It's totally fine. And the intervention doesn't have to happen, but it can be a first step if they want to try that first.
Liza, let me ask a question that I think is connected to that came in, and it's related to: is there a cost ever, like if a formal charge is filed, is there a cost for the client, or does all of this happen for free?
It's a great question. I'm glad you asked it. It is $0, because all of our taxpayer money, you know, goes to fund federal government, including my salary. And so there is never a cost, and not a cost for the employer. If they are found to have committed discrimination, they might have to pay a civil penalty to the Treasury. This is if there's an investigation, not for a hotline intervention, but it is free to the potential victim. And even if my client doesn't think, even if the DOJ doesn't think that there was discrimination, it's still free. Like we had to investigate to see, and there's a lot of unfair things that are not illegal, but you know, you don't know on the offset. And so everybody has the right to file a charge.
Great. Panelists, did any of you, Monica, Katie, or Sophie, have any final comments or burning questions? Unfortunately, we're gonna have to wrap it up here in a minute, but just wanted to check in. Great. Well, thanks again to you all for your time and participation. I know there's a lot more questions out there. You know, what I can say is that, you know, one, and I think we've answered this question a few times in the chat. Yes, you will get the slides. Don't worry. We always send a follow-up email with the slides. Also, the recording of the webinar will be available in the Switchboard resource library. You will need an account on the Switchboard website. It's free, but you'll have to make a login to access that if you don't have that yet. But it will be available there as well. And then one other thing that Saba and I always do after webinars is we actually go back through all the questions and we try to see were there questions that were not answered, or are there challenges that are actually, you know, where people might need technical assistance, and we reach out directly to people after webinars as well. And so if your question didn't get answered, you know, we're going to do our best to comb through all the questions that came in today and see what we missed and circle back to you. We actually just started a couple weeks ago working on a reference guide that we hope will be like a grab and go kind of thing that will talk about different ORR eligible populations and what documents they commonly have, what combination of documents could work, and then also an FAQ at the end, frequently asked questions that, you know, a lot of these questions may end up on the FAQ as well. And so we're going to keep working on this issue, I hope that today was helpful for you all. There will be a survey. You don't need to worry about this link here because it's going to pop up automatically once you exit out of Zoom. But please take a few minutes and give us feedback. We really want to continue improving and just being helpful to you in your work. So please give us feedback. finally, here's our contact information. You can reach us. There's a general switchboard email address you can reach us at. We're also on Twitter, and our website is also there.